The California Environmental Quality Act, better known as CEQA, sparked some heated and passionate debate around the Golden State. How you view the law depends largely on who you are. If you're a government agency wanting to build a new school or a developer wanting to build a new shopping center, you see CEQA as a costly requirement. But if you're an environmentalist, you see it as a law that must be protected in order to save the environment. If you're in business, you might use CEQA as a vehicle to keep opposition out. And if you're a labor union, you might use it as a way to obtain more favorable contracts for your workers. CEQA is over 40 years old, and there is a growing clamor in Sacramento to modernize it, to reflect a California of the 21st century and not of the 1970s when it was first enacted. And as you can guess, the search for common ground for CEQA reform won't be easy. But that search has begun. In November, another in a series of bus tours to help various stakeholders better understand how CEQA works was held in San Francisco. The tour was sponsored by the Silicon Valley Leadership Group and the San Francisco Planning and Urban Research Association, also known as SPUR. Elected officials, environmentalists, and developers all took the tour to look at how CEQA has impacted some projects in San Francisco. California Forward's Cheryl Gattuiza picks up the story.
It seemed relatively simple: convert a motel to a transitional housing for at-risk youth and young adults. The project in San Francisco off Lombard Street was to turn the 29-room motel into 24 separate living units. The project sponsor was the nonprofit Community Housing Partnership, which develops affordable housing for people who need it. Thanks to CEQA, it wasn't simple.
We lost about a year in going through the CEQA process, and as you said, a couple $100,000 of unnecessary expense. And given what this building will do and what CHP does, this is a building that's going to serve transition-age youth who are aging out of foster care or at risk of homelessness. A year delay means that the 25 people who will be living here are homeless for a year.
The Edward II project, that was an example of an inability to use the kind of exemption that really would be appropriate for that project. There are certain provisions in CEQA that essentially have unintended consequences. They are not provisions that necessarily provide for better public information, which is one of the big purposes of CEQA, or reduction of environmental impacts, but they are aspects of the law that are used that can be used to lengthen the process and the review process.
The California Environmental Quality Act was created in 1970 to ensure that state and local agencies assess the environmental impacts on all projects and to mitigate the negative consequences if possible. Now, over time, the law has evolved into an extensive public planning requirement on nearly all projects. Stories like the Edwards project in San Francisco aren't rare. In fact, talk to most developers or city leaders, and they'll tell you CEQA and the form it has taken today delays and sometimes kills projects entirely. Some think that CEQA is outdated and has been expanded far beyond what it was supposed to do. That is, to protect California's environment.
There is a recognition in the room that CEQA has been abused and can continue to be abused to really get in the way of environmental goals that may not have been paramount in 1970 when CEQA was enacted.
In fact, those abuses, as Jennifer Hernandez calls them, often aren't about the environment at all.
Sometimes, those folks may or may not be raising legitimate environmental issues. Sometimes they may be after property rights protection, competitive advantage, labor negotiations. There's all kinds of ways lawyers can creatively use any lawsuit if they're allowed to advance their position, and CEQA is now in that category.
For attorney Hernandez and her clients, reforming CEQA is a major focus for area developers who would like greater immunity from lawsuits that use CEQA to challenge new projects. But environmentalists like Bruce Resnick see it much different. They see CEQA as a defense against irresponsible development and a diligent protector of the California environment. He says the threat of lawsuit is actually very small.
everything tends to be anecdotal. We don't have a lot of studies, but to the extent that there have been studies, probably the best one was in '05. There was the Public Policy Institute of California, or PPIC, a very well-respected, very neutral group. And what they concluded was essentially that CEQA's work. If you go back to look at that report, I'm going to, of course, blank on some of the numbers, but I remember 1 in every 354 environmental reviews was ever brought to court. I mean, this wasn't a huge thing. The vast majority of projects, only 3 to 5% of projects required the large environmental impact report that are costly and time intensive. The vast majority of projects are done through negative declarations or exemptions or other types of things. Even projects that do EIRs, the vast majority of them are built, and those that aren't built, oftentimes it's other reasons than CEQA.
So discussions people were having is a place to start. Hernandez thinks a place to start is by making 4 adjustments to CEQA. 1. Since CEQA predates most federal and state environmental laws, integrate existing law into CEQA and then exclude CEQA lawsuits and challenges in those defined areas like clean air or water. 2. If a community develops a plan and adopts it and your project aligns with that community plan, you can't be sued. The community plan will already have considered environmental risks. 3. Have the person who is suing incur the expense of preparing the official record, which often involves hundreds of digital documents. The thinking is that paying for the record wouldn't slow down a serious, substantial challenge, but might eliminate some of the challenges that are simply delay tactics. And lastly, eliminate the secrecy in the lawsuits and reveal who is behind, which is not required now. So if it is a business competitor, a neighbor, a union, or an environmental group, it will be transparent who is trying to challenge the project. Similar reforms were prioritized at the California Economic Summit last spring. Thousands of Californians at over a dozen regional forums identified CEQA as a critically important issue for fixing the state economy. The summit, which was sponsored by California Forward and the California Stewardship Network, has identified 7 areas, including CEQA reform, as critical to reaching the goal of creating more jobs and improving California's ability to compete in the global economic environments. Agreeing what to reform isn't easy. Resnick says the Planning and Conservation League, which was instrumental in crafting CEQA 4 decades ago, is not opposed to reform. However, there needs to be a balance. And he says the last-minute attempts in the summer of 2012 were rushed.
There's some dispute about what some of the proposals were that were on the table last session. We're willing to look at some reforms. We think, for example, a lot of the delay around CEQA relates to the preparation of the administrative record. That takes a long time. It slows up, if there is going to be a legal challenge, not having the administrative record, electronic preparation of the administrative record, something we're very supportive of.
If anything is going to happen, it will happen in Sacramento. And the point person is an up-and-coming senator from Kern County. Michael Rubio, the new head of the Senate Environmental Quality Committee, was involved in many discussions on the San Francisco tour, asking questions and looking for common ground.
We pass new laws to be very forward-thinking in a responsible way so that we can lead the nation on these land use policies. What we're not doing is updating CEQA so that it is consistent and up to date so that it's in line with those policies. That's what I think we need to do. That's the balance that we need to strike here, is updating and modernizing a very good law that's done well in the state for 4 decades, but now, because of its vulnerabilities as being abused, we can eliminate those abuses and still protect our environment.
It is obvious that CEQA is not going away. There is great support for the core principles of the Act, which is to protect the environment.
I think we need to revisit it, but I would not be in the camp that says we have to eliminate CEQA. I mean, the environment, if you think about how important it is to protect it and protect open space, I mean, that's a legacy we leave to our children, our grandchildren, our great-grandchildren. At the same time, it shouldn't be difficult to restore a transit route. That shouldn't result in a whole new EIR. So there's got to be some common sense solutions that we have here so we can achieve both goals.
So what do Californians want? They're worried about the economy and want to see more jobs created, but they don't want to see the environment compromised. Can we do both? Well, that's why California Forward is covering this issue. The gridlock of Sacramento is in many ways symbolized by the debate over CEQA. If common ground can be found on something as intractable as CEQA, it's a sign that state government can begin to function in ways its citizens deserve. Senator Rubio made it clear that he is committed to reforming CEQA.
Today's tour really brought into focus some of the key issues that we need to work on in Sacramento in finding the right balance so that we're able to preserve the environment, protect the environment, and at the same time move our economy forward and create the jobs that are needed here in California. As you know, we are leading a working group effort right now, and so this could not come at a better time for us.
For California Forward, I'm Cheryl Gitchwiza.